Good morning, everyone. So today I'll be taking a class relating to general differences in torts. So, what are the general differences? So, in torts, always when we does any tort, always we are held liable to pay the compensation for the wrongful act which we have done. But in this unit, we can see that there are certain general defenses. So, because of the general defenses, even if we have done some tort, we are exempted from paying the liability or the compensation. So, acts done in certain special circumstances which cannot be considered as torts. So, that is in the absence of those circumstances, the same act may become a tort. So, acts done in such circumstances are known as defenses of torts or justification of torts. So, there are different defenses for different torts. For example, in the case of defamation, the defense of justification of truth. However, there are certain general defenses which apply in every tort. When the plaintiff brings an action against the defendant may take any of these defenses and avoid the liability. So, the following can be considered as the general defenses. The first one is voluntary non-fit injuria, act of God, inevitable accident, private defense, acts of necessity, mistake, statutory authority, judicial acts, quasi-judicial authority, executive authority, parental and quasi-parental authority, exercise of common rights, acts causing slight harm. So the first one is said to be the voluntary non-fit injuria. So voluntary non-fit injuria is nothing but harm suffered voluntarily by the consent of the plaintiff. Is not at all actionable. I have agreed for something. With my own consent, I am ready and voluntarily I indulge and I give the consent. Hence, it is not at all actionable. So, this principle of law is generally known as a voluntary non-fit injuria, which means to one who is willing and who has already given the consent. So no injury is said to be done. It is considered as no any injury is said to be done. So when a person consents to the infliction of harm upon himself, he cannot later claim compensation because he has willingly given up his legal right, consent. Maybe it is said to be expressed or implied, maybe through words or then the written format, or maybe in any ways by the express ways he might have told, or even certain times it is said to be implied. So this means a willing person cannot complain of an injury that he voluntarily accepted. So for example, if a person goes to a doctor for a blood test, he cannot sue the doctor for the pain caused by the needle because he consented to the procedure. So this is an example of express consent. Similarly, when a person goes to watch a motor racing competition, he accepts the ordinary risks associated with that sport. So, however, only those risks that are reasonably accepted, which are said to be covered by the consent. For example, if during a motor race, A poisonous snake is hidden under a spectator's seat, bites him. So the organizers may still be liable because such risk was never consented to. So we have a case law, Paul versus Brooklands Auto Racing Club, 1933. So the facts, the plaintiff went to watch a motor race, which is conducted by the defendant. And during the race, two cars collided and one car crashed into the spectators, injuring the plaintiff. So the court held that the defendant was not liable because the plaintiff voluntarily accepted the ordinary risk associated with motor racing. So in the same way, we have another case law, that is Lakshmi Rajan versus Malar Hospital Limited, 1993. In this case, the facts, the plaintiff was admitted for the removal of a lump in her breast. During the surgery, the doctor removed her uterus without obtaining her consent. So here the court held that the hospital is said to be liable because the patient had consented only to the breast. So the court held that the hospital is liable because the patient had consented only to the breast operation and not to the removal of the uterus. So consent certain times, if it is obtained by fraud, under that situation, we have a case law, R versus Williams. The facts. The defendant is said to be a music teacher, falsely informed his 16-year-old student that sexual intercourse would improve her singing voice. She consented, believing his statement. So the court held that consent obtained by fraud is not a valid consent. Therefore, the defendant could not rely upon the defense of voluntary non-fit injuria. So the knowledge of risk is not consent. Smith versus Baker. So facts. The plaintiff worked near a crane where heavy stones were regularly lifted. Although he knew the work was dangerous, no warning was given before stones were removed or moved over his head. So one stone fell and injured him. So in this we can see the judgment that the House of Lords held the employer liable. So the court stated that mere knowledge of danger is not equivalent to consenting to that danger. For the defense of voluntary non-fit injuria to succeed, there must be knowledge of the risk, free and voluntary acceptance of that risk. Knowledge alone is insufficient. So the consent obtained under compulsion. So suppose an employer orders his servant to work on a dangerously hot roof and threatens dismissal if he refuses. So if the servant suffers illness, so the employer cannot plead voluntary non-fit injuria because the servant did not act voluntarily. He acted under compulsion. So therefore, consent obtained under economic or other pressure is not a valid consent. So what are the essential elements? For this defense to apply, the plaintiff must have full knowledge of risk. The plaintiff must voluntarily agree to accept the risk. So in the same way, we have Smith versus Baker. The knowledge of risk is not equal to the consent. The worker had no any genuine freedom to refuse the dangerous work. So, the knowledge of risk itself cannot be considered that it is equivalent to consent. Even if I have the knowledge and I have consented, even though it is said to be a very risky thing or very dangerous, that cannot be by itself cannot be considered as my consent as I have the knowledge about it. So in the same way, we have Hams versus Darby. Hams versus Darby. The plaintiff's pigeon strayed onto the defendant's land and started eating his pea crops. So the defendant attempted to drive the birds away but used a gun and shot at them. 4 pigeons were killed and 1 was injured. So, whether a person is entitled to kill or injure animals that trespass on his land in order to protect his property. So, here we can see the judgment that the court held in favor of the plaintiff. So, a person has the right to protect his property, but the force used must be reasonable and proportionate. Shooting the pigeons was considered an excessive and unnecessary. So, therefore, the defendant held liable for the damages. A person has a right to protect his property, but the force used must be reasonable and proportionate. So, shooting the pigeons was considered as excessive and unnecessary. Therefore, the defendant was held liable for the damages here. So, the principle, while exercising the private defense only, the reasonable force may be used. In the same way, we have Brown versus Kendall. So, the defendants and the plaintiff's dog began fighting. The defendant tried to separate them using a stake. While doing so, he accidentally struck the plaintiff in the eye. So the judgment was the court held that the injury resulted from an inevitable accident because the defendant had acted carefully and without negligence while trying to stop the fight. So the next topic would be act of God, that is vis major. So this topic can be even asked for a short note. So the defense of act of God applies when damage is caused solely by extraordinary natural forces and without any human interventions. Such events are so unusual that no reasonable person could have anticipated or prevented them. So, to claim this defense, the defendant must prove that the event was caused entirely by natural forces. There was no human intervention. The occurrence was extraordinary and unforeseeable. So the defendant was not negligent. So the example includes like earthquakes, cyclones, tsunamis, volcanic eruptions, exceptional floods. So ordinary rainfall or seasonal storm generally do not qualify as an act of God because they are reasonably foreseeable. So Kallulal and another versus Hemchand and others, 1957. During the rainy season, the wall of the defendant's building collapsed, resulting in the death of the plaintiff's 2 children. So the defendant argued that the accident occurred due to heavy rainfall and therefore amounted to the act of God. So here the judgment, The Madhya Pradesh High Court rejected the defense. The court found that the rainfall was not extraordinary and that the defendant knew the wall was weak and in a dangerous condition but failed to repair it. So the defendant was therefore negligent and held liable again for the damages. The principle in this case is said to be a natural event will not amount to an act of God if reasonable care could have prevented the damage. So in the same way, we have inevitable accident. So what is an inevitable accident? So here, an inevitable accident is an accident. So that could have not been prevented even after taking all reasonable care, caution, and skill. So it is an event that occurs without negligence and despite every reasonable precaution. So the essential elements. So the act must be lawful. There must be no negligence. The accident must be unavoidable. A reasonable care must have been exercised. If these conditions are satisfied, the defendant is not at all held liable. So Holmes versus Martha, 1875. So the defendant's servant was driving a horse-drawn carriage. Suddenly, barking dogs frightened the horses. So despite every efforts to control them, the horses bolted and knocked down the plaintiff. So issue whether the defendant was liable for the injuries frightened caused by the frightened horses. So when no negligence at all is said to be existed in this. So the judgment is the court held that the defendant was not at all held liable. The court held that the defendant was not held liable. Actually, the accident was unavoidable despite reasonable care and therefore constituted an inevitable accident. So, if the defense is said to be proved that it is an inevitable accident, hence he need not pay any compensation and he would not be held liable. In the same way, a person is not held liable for the injuries resulting from any unavoidable accident when he has exercised a reasonable care. So in the same way, we have Stanley versus Powell, 1891. So the plaintiff and the defendant were members of a shooting party. So the defendant fired at a bird. Again, the bullet struck a tree and ricocheted and accidentally hit the plaintiff, which caused a serious injury. So issues were whether the defendant was liable for negligence. In this case, the judgment was that the court held that defendant was not liable. The defendant had exercised proper care and the accident was entirely unforeseen. So the recorded of the bullet was a pure accident and therefore so the whatever is said to be amounted, the effect can be considered as an inevitable accident. So what is the principle which we see in this is said to be if an act is performed carefully and lawfully and injury results from an unforeseen and unavoidable event, there is no any liability. So in the same way, we have right to private defense. So in this, it is permissible to use unreasonable force to protect one's person or property. Essential conditions for this defense include the use of reasonable force and the threat for which the force is being used. must be immediate and reasonably foreseeable. So that is, the aggressor must be capable of causing the harm, and it must be necessary to use force, and any immediate help must be unavailable to exercise the right to private defense. So some prominent cases that gives useful insights into this defense are as follows: Birds versus Holbrook. So in this case, the defendant set up spring guns in his garden. So without any notice or giving any kind of warning about the same. So the plaintiff, who was a trespasser over the defendant's land, got injured and brought up a suit against the defendant. The defendant pleaded that the traps were set up for the protection of the property, but the defense of a private defense was not granted by the court because it was essential to post a warning or a notice. And without either, it seems more probable that the defendant wanted to scare the people off rather than protect his property.